fold, these appellants have now been displaced. So a new list has now been drawn up purely based on merit. Now taking the certificates, including those of the petitioners and others similarly placed, and a new merit list has been drawn up. So that is what the government has done in this case. But yes, in principle, I cannot possibly disavow myself from the stand taken before the learned single judge. That would not, I agree completely.
Yes, so that will be taking a departure from your own notification 86. If you say now we'll go and proceed further, treating these candidates who have submitted the certificate to see to request you to consider income of the parents, then there will be a departure by the state from its own notification.
There is some discussion, although there is nothing to place on record. The DP at the Administrative Reform Department is having a relook at 12/12/1986, because none of you also know 12/12/1986 precedes the judgment of Uttarakhand. There have been a number of developments since then. So possibly the 12/12/86 circular has to have a relook, has to be done at some point in time. After Indira Sawhney's judgment was, the law has developed significantly. Ashok Kumar Thakur's judgment came. Now, it may not be correct on the government's part to even submit this, but yes, it should have had a relook much earlier.
What is the mode you're adopting now to accommodate everyone now? Is it a new notification?
No. The same notification which was earlier there, the provisional select list was drawn up. Now a new provisional select list has been drawn up and the final select list also.
How does it differ from the question what we asked initially, if there is a possibility of accommodating them?
Now they have been displaced on
No, you express the apprehension.
Yes.
In the case, it will open up floodgates tomorrow.
Yes.
People, I mean, how does it differ from the one what we are requesting you, and then
yes,
what
I
you
can explain that. Now, all the appellants are admittedly applying under the OBC category, under various whether it is whichever category under OBC. Now they are applying under OBC. Now the OBC roster has been filled up. Now, if we were to accommodate them, we would necessarily have to accommodate them under some other roster. That may open up the floodgates, what I was saying. But I can verify if the which is why they have been displaced. Otherwise, the question of them having been displaced may not have arisen at all. Now, if the only way we can include them is possibly, we can obviously not under SC, or any of the other categories. General merit is the only open category. Now, under general merit, because there are a number of applicants who have already been disqualified based on merit. Now, we want to accommodate them.
that's exactly what we are asking.
Yes, sir.
How does this apprehension of yours
Yes.
differ from what you've already taken? You have not called for a new notification.
Yes, sir.
With the old notification, you're accommodating all the candidates.
Now, I'll explain.
What is the
now I understand what you want to ask.
What is the mod you're adopted?
Yes, sir. Now what is being done is there was a provisional select list under the OBC category where yes, the appellants were there. Why were they there? Because all the petitioners as well as persons similarly named petitioners who submitted income certificates of their parents, they were outright rejected. They were told that your parent certificate cannot be considered at all because under the 12/12/86 circular, it will only be the husband. Now, all of them were rejected at the threshold itself. Now, by virtue of the learned single judge's order, they have come back into the fold because we are considering them as well. And
On what category?
Under OBC. Under OBC. Why they not disqualified? Why post proposed dishonorable court is they were pushed out of OBC and pushed to general merit, where they did not qualify under the open general merit category. They filed a petition alleging that our rejection of the rejection of our income certificate itself is wrong at the very threshold. Because the law under Surinder Singh and various other judges said that it is only the parent certificate. Now that fell favor with the learned single judge. And therefore,
What is the stage of this subsequent development?
I'm sorry.
What is the stage of your subsequent development?
A final select list has been drawn up. Now, as per the interim order passed by this honorable, no appointment orders have been issued. I'm told that document verification is ongoing and is at the final stage.
How it can be again a final select list then? When now you say that there will be a total change pushing.
The change already happened. That is where.
No, change will have to be effected now, putting these candidates not in the general merit category but in OBC.
Yes, now the petitioners and persons similarly placed petitioners have been included in the OBC category. And also importantly, as suggested on the fact that the OBC category also has been drawn up based on their merit, their individual merit. So why they got displaced or why the appellants and persons similarly placed have been displaced is because when the OBC list was drawn up, as per the order of the learned single judge, by accepting the income certificates of the parents as well.
No, this final list, what you have prepared now,
Yes.
is from the provisional list candidates.
From the second provision.
New provisional
The
list.
whole provisional list was abandoned. That was withdrawn. A new provisional select list was drawn up.
When was it drawn?
23rd of February 2023.
After this order.
After the single judge.
Correct.
It's after the single judge's order. And on 7th of March.
So what happens to those people who were there in the first provisional list?
The list has been drawn up, has been redrawn up. That was abandoned.
The criteria for the first list, provisional list, criteria for the second provisional list are
Yes.
different.
We were removed from the provisional list.
Correct.
Pursuant to this order in the
So
revised-
therefore, the criteria differs in respect of both the provisional list.
The criteria would be the same,
How?
except the fact that certificates of those candidates who gave their parents certificate have also been included. Now, there is an OBC category.
So that's
No.
why, it's
Yes.
exactly the point. The first provisional list you prepared
Yes.
was on a criteria.
Was on, not criteria, was on based on certain certificates. Yes,
Correct.
yes, criteria.
There was one criteria
Yes, we
To
don't-
classify that.
Yes, only.
Now, because of this order, you have come out with the second provisional list,
Yes,
which is on a B criteria,
not B criteria, A.
different from the A.
A plus B, because now husband. No, correct, which is
So therefore, there's a change in the consideration.
Yes, sir.
Ah,
Changing the rules of the game of their judgment will say that as far as eligibility criteria is concerned, I'll come to that. If I just draw my laws, other than.
no, why we're asking is, will this second exercise of coming out to the second provisional list will not give up open to floodgates as you are comprehending?
Which it can't.
So how does it differ?
No, but
The basic criteria
is that
only alternative for them is to go for a
Fresh recruitment.
Because suppose there are any number of married women candidates whose parents may come within the less than the creamy layer. But because their husband was falling outside the creamy layer, they might not have applied. It will be mallots. It will be if they do as they have done now. It will be a reward on litigative persistence of the
Yes.
litigant and not on the merit of the candidate.
How will you justify that? The second provision list.
Already explained possibly.
Intentionally, I made in the investigation, the impact is only 300 to 350. Those who are before the court, is under that. That's all.
No, that probably is not the situation, that impact is only 300. Now, there is a lot of those candidates to whom the senior counsel is representing, and yes, probably now if we are taking this, permitting it, he rightly says that those who probably have not submitted their claim, treating that my parents, it is to be only considered of my husband income. They would say no, in this scenario, we could have been also.
See, when you prepared the first provisional list, you have allowed some come on and rejected some not to come on the provisional list. Now, the same provisional list, you have made some alteration. If this alteration was made in the first list itself, the persons who were rejected also could have been accommodated. No, aspirants were there who probably could have fit into your second criteria.
Just a moment. So,
The orders say they have accommodated candidates who are given husband's income certificate as also the wives who have given parent certificate. That's the order for the new.
No, in which category?
That's for OBC. In OBC also there is a rank. That's depending on marks, but accommodation is for both. Now they have not taken a stand that whoever has given the husband certificate, I am going to eliminate them. That's not their stand.
husband certificate.
You are adding some benefit and you are adding something.
That's the order.
No, but meaning thereby now those who could have been a contesting candidate with their parents' income, which could have been this class could have been treated as a candidate, yes, for OBC and not belonging to creamy layer class. They are kept out of consideration. No, they have not filed their claims. They are not because they were under impression.
They have filed their husband's claim.
Ah,
But they have been accommodated.
No.
those who submitted application, those who probably on other factors, other considerations, academically fulfilling the condition, but for this they could not have filed. They are kept out of consideration.
Somebody who has filed for marriage, but for marriage, either has husbands or parents. Somebody has
One thing, Mr. Vicky, just please consider this. Now, instead of this, taking a stand, applying the criteria, giving a go back to your 86 notification, if you are starting the process, why not a fresh process? You prescribe whatever norms you want to prescribe, start fresh process, allow everybody to compete with, and then select candidate. Otherwise, also you say that we are in need of posting urgent need. You say that the process gets complete, and by adopting that process, norms you can prescribe as you say. And if the fresh process is initiated, nobody can then say, because the field will be open. One ground can be always there that once you start process, then changing the rules of game, the state government cannot accept this policy. You come with rules, allow us to claim, to stake our claim. In that process, if you say, okay, a fresh process will initiate it, we'll fix the norm. Accordingly, we'll go on with the process. We'll do that within see if you are in a dire need, complete it within 12 weeks, 16 weeks, whatever it may be. But this process, as there will be so many ifs, buts, difficulties. How did we consider of those who are kept out of consideration? What about them who could have been filed their application, but for this change in policy suddenly? You just consider if that a fresh process can be initiated and everybody will be permitted to participate. Let this, because only on a provisional list, nobody can say that appoint me. There shall be a process which ought to reach to finality. By
Now, after the current single, there is a final.
but that final list is a defective, no? Ultimately.
Experience speaks.
Proceedings record. There are about 1850 proceedings.
No. Senior counsel, this is what is running. We wanted clarification. Even if you're accommodating the candidates who were listed in the first provisional list with making certain adjustments in the second provisional list, as he was trying to point out, we asked repeated question to him. Where does the notification makes a distinction between married, unmarried, and widow, right? He said it is up to them. What we could make out is maybe I, as a candidate, expected to know the law. I should have filed it. There are one who do not know. Now take the example of one who knows about this, saying that yes, I'm a widow. I will have to apply my. I'm a married person. I'll have to apply husband. Those candidates are left out now. No, not in the list. Even prior to making the list, they had no opportunity to file itself. For example, if I knew that my application, irrespective of my marital status, would be accepted, I would have applied in all the categories. Because I knew about 12/12/1986 order, I did not make an application, thinking that my father's income will not benefit me. Now that I recommend father benefit, I am deprived. even the first provision list.
Sure.
So therefore, those people will not keep quiet. Correct. No, kindly look at this. If your final list will come, now I am a candidate left to the first provision list. I look at I fit into this list. The final list, what you have brought in now, probably if I had made an application as made in the first and second provision list, I would have been an eligible candidate. So that class will be left out.
Your lordship's consideration is
It's difficult for everybody
Ah.
to contend. They were not aware of 1286.
Correct.
clause. The forum gave gives alternative. Ultimately, the minimum requirement of application is application of mind. Husband is also mentioned, father is also mentioned. Whether I have to show my husband's income or father's income. Then they would have realized that there is a government order. You read that, I was
No.
not aware of the government order.
Therefore,
It is an
Yes.
impossibility.
Correct. So therefore,
therefore, even in the first session also, if you were so sure of that, this will apply this, you could have prepared the forms accordingly, leaving a little scope, so that the candidates who are claiming, they could have accordingly filled in the form.
F3.
Categories.
And also take visibility. In fact, the application is in form A, B, or C. The certificate is given in D, E, or F. So what my
We are at least
Tasildar.
we are at least clear now.
Yes.
That is a potential issue
Yes.
to be determined as and when these issues are raised.
Now, one appeal is only the case of the additional advantage can take the positive instruction. Whether the state government is giving to go by to 1286. According to the, I have a confidence that the government will stick on to 1286. Let it take positive instruction. If they want to change-
Because this, your lordship's concern is, on one hand, people who are given certificates in Form F regarding the husbands, they will be left out in the new provisional list. And will be eliminated one day. And that the Form F, which contains the income of the parents, will only be considered. The proceedings which they have, my lords, drawn up shows they have taken both into consideration.
No, we are not concerned only with the candidates whose names are different provision list. We are looking at all those candidates who applied for the post. What about them?
Applied for the
Who are
post,
eligible to apply?
with Form F, with Form F.
Correct. Have you accommodated them?
That's what the rules say.
That's we don't, it's for the state, our statement of objections filed on 18th of
So
April.
are you saying even the rejected application reconsidered?
Yes, that's what they've done. Your lordship may see their.
Rather than trying to orally explain, kindly see the procedure. The objection filed on 18th April 2023.
In this appeal itself.
Yes, yes.
We have filed our objections. Remember, I'm not sure.
18 April.
April we filed.
18th April, okay. 1 to 26 state, is it the same? Just a moment, I'll refer to the
Statement of objections by 1 to 26.
1 to 26. And that is filed through special officer, one Mr. Prasanna Kumar. Sorry, Srimati Prema Prasanna Kumar.
Yes.
Is it that?
Yes.
Just a minute. Yeah. मिल गया मिला. Which part you would like to read?
Transcribed copy of the proceedings of the meeting held under the chairmanship of the Minister of Primary Secretary. Page 12.
Yes.
I just read the entire. The meeting started with also Chief Secretary. 22,432 candidates have qualified in the public. 1:2 checklist for the recruitment of graduate primary teachers. The appointing authority has verified the original documents of the said candidates. While 1,840 married female candidates have mentioned married in their online application, mentioned their husband's name, and submitted their father's, mother's, parents' income certificate. Reservation request of such candidates by government order dated 12/1986 will not be entertained. 1:1 provisional list has been published by a competent authority on 18/11/2022 after verification of original documents. Certain married women candidates were submitting their father's income certificate who were not included in the said list and filed application number so also which is the included order. Srimati Akshara Chawla and other in the Honorable High Court of Karnataka dated 31/2022. In accordance with the procedure laid down to the Honorable Court, extract of which is as under. These are the 4 clauses my lords have already seen. The Honorable High Court passed this judgment referring to judgments given by the Honorable Supreme Court in the case of Shri Surendra Singh versus Punjab Electricity Board and others in the same case and others who also judgment. Referring to the judgment given by the state government versus Karnataka Examination Authority and others, the judgment is given to consider the income certificate of the father. After a long discussion, this is important, after a long discussion, it has been decided to carry out the following resolutions. The Honorable Advocate General opined as follows, in view of the orders of the Honorable Supreme Court and High Court, since the appeal is less likely to be granted and the services of the teachers are essential in the educational interest of the children, it is imperative to complete the recruitment process at the earliest. And as per the judgment of the Honorable High Court, it is not appropriate to file an appeal and the government shall take an administrative decision for the selection process. A logical conclusion necessary. Candidates are free to approach the court if the current recruitment is delayed due to large scale, there will be shortage of teachers. If the candidates who have submitted the income certificate of the father or the parent as per the judgment of the Honorable High Court are considered. As per the recruitment notification, there is a possibility that several candidates who have already been placed in the provisional selection list and who have already been placed in the 1:1 provisional selection list will be left out of the recruitment. This may lead to further legal complications and delay the recruitment process further. Therefore, it has been decided to take precautionary measures to file a KBS in the competent court so the appointment process does not become legal complicated. As the notification for the upcoming recruitment of teachers has to be issued so that cases do not recur, DPR is requested to issue appropriate guidelines to the recruitments of various departments of the government in view of the judgment of the Honorable High Court. The judgment passed by the Honorable High Court, the state is reserved liberty to regulate this procedure by continuing the recruitment and taking it to its logical conclusion. In the said background, the candidates who have approached the Honorable Court claiming that the father's income certificate has been limited to the current recruitment and not considered, even if they have submitted the father's income certificate. The eligible candidates who have submitted the father or parent's income certificate and the candidates, this is important, and the candidates who have submitted the husband's income certificate who are already in the merit list will be considered on the basis of overall merit. Revised provisional list 1:1. It has been decided to prepare the selection. So therefore, all.
No. This 22,432 candidates,
Yes.
who are they?
They are qualified in the original 1:2 checklist.
How?
That include general merit, SC, NG, and various categories.
Whatever the husband's income.
This is the entire, let me clarify. Let them not confuse this. 22,000 candidates, the entire list, they are called in the 1:2 ratio. For one post, 2 candidates will be called. That
No, correct.
includes
What was the,
SC,
no, correct. This 22,432 candidates.
Yes.
What was the eligibility criteria considered for them?
So originally, one of the eligibility criteria was as far as OBC is concerned, as far as SC, ST, there is no question of income certificate. As far as GM is concerned, no question of income certificate.
Correct.
So the issue arises only for OBC category. As far as OBC category is concerned, originally the government rejected.
OBC because of total agency. My learned friend should not.
I didn't say anything, sir.
No, we just,
No, it's an.
no. Senior counsel, we just want to know.
OBC only total agency. Otherwise, no.
No, correct. Well, we wanted to know this 22,432 candidates to whom you declare qualified on what basis?
They were drawn up on the merit list as far as
No,
GI.
before you could go further, with this change in the stand of the state government, if this stand was available to before qualifying this 22,000, was there a possibility of some other candidate being included in that?
I would not think so, because now as far
How?
as. I'll explain why. As far as the candidate.
If this last paragraph 4, was made known before you qualified this 22,432, what would have been the position?
If this position of the state was known, all that would have changed is that the OBC merit list would have changed.
Correct.
That's all would have changed, nothing else would have changed. OBC merit list would have changed, yes, and possibly, my lords, all those candidates who had given their, let us assume there's a change in policy. All those candidates who had given their husband certificate would have been rejected. Now, let us assume that there is a change, although I'm not saying there is a change. All those people, all those candidates who gave the husband certificate would have been rejected because only parent certificate were to be taken into consideration and a merit list would have been drawn. Now what has been done is, because of, yes, I can't differ from the fact that this issue has been created by the government itself. Now, because of the original statutes,
With the number 22,430. The question here is, as again we ask, are there any other candidates who would have qualified if you had changed this game earlier?
no, now because what we have now done is taken all the candidates who have given their.
That is after you have made this filter.
No,
After you have made this filter, 1:1, 1:2. You see,
23,000 comes because of total 96 passing. Now, final provisional. You are going to tamper the provisional based on the new rate.
I'll submit this. Your lordship, right?
now
This new
50,
criteria
50,
applies to
no, the total posts were 15,000.
Yes.
15,000. This 22,432 candidates qualified at the ratio of 1:2. So that's the filter there. Correct. Correct. There's a filter there.
Yes.
Now, when you made this filter, this rules had not changed. If these rules were made known then, what would have been the position?
The position, well, what we have done now, what the position.
Will those people not be deprived of the opportunity of contesting? Well, that is what our concern is. What you have done is, till you arrived at a figure of 22,432, you had one rule. Moment you had this 22,432, you changed the game. That is not permissible.
That's not, that may not be the position.
No, that is very obvious, sir.
Persons like petitioners do not have been 22,000.
We are not concerned about the petitions now. We are now concerned about the people who were there before 22,432.
They would have been rejected at the outset. In fact, because I'll explain why, because their certificates were at the threshold rejected, so they could never have been 22,000.
No, we don't know the material.
So therefore,
Whether they were rejected because the husband's income, whether rejected because the parents' income. Why were they rejected?
They were rejected because they had submitted the parents' income and not the husband's income.
Now you're changing that.
Yes, sir, which is why now all of those persons who had been rejected, now they have been brought back into the fold. They were outside.
In that case, this number may vary, no? In that case, if you're bringing back all those persons whose applications were rejected,
Yes.
this number of 22,432 may vary.
Yes, sir.
But I'm not understanding.
No, but this, no, don't go by that. But now with this order, we wanted to know whether this number is changed.
No, in fact, if you are allowed to see, after the done only 1:1.
Correct.
Done only 1:1.
So, no.
Done only 1:1.
If-
So
if-
that
if-
will- that will be
If it's giving a semblance of a new exercise, then it may have to start from the notification date itself.
There, fellows,
If you are trying to do from 22/4/32, it is not a new exercise. With the same notification, if you are reconsidering all the application with the change rules, this number may also have to change.
that may not change because now again I'm trying to explain that the only so-called change in the rules of the game will apply to OBC candidates whose applications have been rejected originally because they submitted the wrong certificate, because they submitted the error certificate. Now they were completely left out of the category of OBC and included in the general merit where they did not even qualify. They were outside the 22,000 extent. Therefore, now by virtue of the learned single judge's order, they have been. They were shifted to JM, I'm sorry. They were rejected from the, I misspoke, they were rejected from the OBC category and they were included in JM. Now, my lord, by virtue of the learned single judge's order, since we have accepted the income certificate of the husband as well as the parents, a fresh list has been drawn up purely based on the merit of the interstate candidates itself. Only the OBC category, if at all, if it will change. The other categories will not change.
Very difficult to accept.
The whole basis of a long case category is changed. And then even the other one will
We made it very, no.
It will be very difficult to accept that there will be no change. This certainly will lead to a change in the position. This will also lead to, as we are consistently finding that probably those who could have claimed this, their claim in the process.
Suppose I'm married, paying the income tax, IAS officer. You apply the new law. 3 years back. For very carefully, my lord, your lordship has to examine the order of the legislation like that without a prayer, declaring Protocol 86 is unsustainable, unconstitutional. You have to get the power at a single time. When the decision, judicial review is available only to the DB, not to the single. No challenge. Let the state government get a positive instruction whether they are going to review Protocol 86.
There are judgments of this court, it's a DB, division bench and single judge which have consistently, it is the income of the parents which has to be taken up. But what I would suggest is, let them have a hearing, let them come out with figures. Number of posts, this many posts. So every post will have reservation on percentage. Out of 20,000 or 11,000, how many are posts? Some will go to SC, some will go to ST, OBC. Then comes the remaining will be TM. If we get the figures, then they'll tell to merge that we are.
No, but then as per the submission of the learned council, AG, how the fitment of all these is in the general merit category. They are not saying that they will be in different different categories.
In fact, the redrawing of the list only is for the general merit. Of course, there will be certain people taken out of the general merit and put under OBC. Now, was a petitioner, for example, only for example, were taken under general merit. They were aggrieved by that. Therefore, now by virtue of their certificates being accepted, they are now considered under OBC. So there will only be some change to that extent. Now the general merit list will largely remain the same except those people like the petitioner who have been shifted to OBC. And more important was people like the appellants, their certificates have not been rejected. We have not said there are changes in the rules of the game. These now you are out of the OBC category itself. We have included them also in OBC category and said here we have drawn up a fresh merit list purely based on merit. So therefore, there are candidates who have submitted their parent certificate and there are candidates who submitted their spouse's certificate who are now featuring in this OBC merit list. Now the appellants before my lords are not in the merit list, which is why they are agreeing. Now there are persons similarly placed who have submitted their husband's certificate who are in the list.
Subject to marks.
Subject to marks.
Clarify by way of.
After reservation, OBC.
See, they were, as per your original notification terms, they were entitled to be considered under the OBC category.
I have to agree, they are agreed because supposing perhaps one of the candidates, who is one of the applicants has got 45 marks. And somebody else who has got 46 marks, he will be placed above it, that is the only grievance. We have not said you are out of the process itself. So one more mistake, let it happen for each country.
More, but person who are not eligible under the reservation applicable rules. By bringing them as reserved candidate. We have been thrown out of the select list because.
They are
those
one less
candidates
candidate.
have been inducted above us.
Yes, they were less.
Answer is one thing. If selection is only on marks and no reservation. I have followed with learned advocate proposition. Here it is, merit, when you are selecting a candidate for reserved post, merit amongst the reserved candidates. Not the merit amongst the entire thing. By including the merit,
How can you drop an OBC list? And then an OBC list has to draw upon merit itself. You can't even, I understand that, they cannot be pitted against a general merit candidate. But they are not being pitted against a general merit candidate, they are being pitted against a fellow OBC candidate.
a ineligible reserved candidate. How can you?
Right, we are going back to the exactly the same thing as to whether validity of Form F can be gone into. He has a Form F, I have a Form F. Can the selecting authority say, I will not accept your Form F? That was never the rule of the game. That is all. We also.
But if this principle is applicable, merited candidates can be included in the SC, ST category.
Unless.
Therefore,
They will never be.
This case, they will not come in here.
How will they come in?
Reasons. There is another error committed with the non. We not facing the entire inability of the reservation certificate. That is the matter will have to be decided. And it is the jurisdiction selecting authority. That is the single just says, they have no authority to go into validity. Who has gone into validity? Entertainability and validity are two different things. Stating, assuming everything stated in the certificate is correct. Before I grant the reservation claim, selecting authority has a duty, whether it is in proper format, whether it has been issued by the competent authority, whether it is in accordance with the rules. What is stated there, whether it's true or false, that is a totally different thing, just to go under the scrutiny committee constituted under the Reservation Act. That is another single judge said, selection authority has no authority to go into the validity of the income certificate. And all these judgments which have been rendered by this court, which has mentioned the word, where it has been reviewed later, they are based on the Punjab Surinder Singh judgment. Surinder Singh has no application here. Surinder Singh did not say what is family, what constitutes family income. All that Surinder Singh said was, look, Punjab government has adopted 1993 OM of the central government, which says candidates' income has to be excluded. And you have taken the candidate's income into account, therefore it is wrong. The question of family never came in the Surinder Singh. Similarly, Sunita Singh. What is said in Sunita Singh? Sunita Singh said, marriage does not change the caste. It was not concerning income. It only said, when a forward community girl marries a scheduled caste boy, she does not get the status of a scheduled caste to claim reservation. So wholly irrelevant judgments they apply. And they throw out of the selection. This is a matter of course. They have to be decided on merits.
Filter is made.
As to anyone who had given farm names, whether they have considered, they let it.
That figure of 22,442.
Exact numbers in.
Whether whether the exercise prior to that is required to be done again.
I will give the exact figure, how exactly we worked out the resolution on the meeting, how that was worked.
Marital 1286 is under 16. I don't think the present government will go out of this.
No. 1286 remains. No, that's one thing. Because they are not saying that giving a go by to that. They are not saying that either. They are only saying that provision list number 1. There are provision list number 2 have made, making this adjustment. That's all. They are not giving go by to 1212. What we are concerned is, if this procedure adopted by the government is allowed, the candidates who are left out of the magical figure of 22,442, what happened?
Correct, that issue is another one.
In this.
Whether the government is going to
You-
go by to 1286. That's most important. Because to claim the OBC, this is the basic.
You see that paragraph, page 12.
Yes.
Read that paragraph once again.
The first paragraph.
That's start with 224.
432 candidates are qualified in the published 1:2 checklist for the recruitment of graduate primary teachers. The appointing authority has verified the original documents of the said candidate, while 1,840 married female candidates are mentioned married in their online application and mentioned their husband's name and submitted their father's or parents' income certificate. Reservation request for such candidates also will not be entered. So those people, those 1,840 female candidates, they were left out of the fray of OBC because they were not entirely left out. Their applications for 1,840 female candidates who gave their parent certificate were not considered under the OBC category. Why? Because the government applied 12 to 1886. So those 1,840 people, some of whom approached this honorable court, were also considered in light of the learned single judge's order, and a fresh list was drawn up for OBC's merit by obviously displacing these 1,840 if they were in general merit into OBC, by virtue of which some people like the appellants have now been displaced. Now, as I was mentioning earlier, merit cannot be given a complete go by if there are 100 posts and 200 applicants in OBC one. How do we draw up the 100? Can we say merit is only traceable to general merit? It can't be worse. Even under OBC, SC, ST, from time immemorial, it has been drawn up the same way.
But now how you can justify this second part of this para when you say candidates this 22,432 candidates while 1840 married female candidates have mentioned married in their online application, mentioned their husband's name, submitted their father, mother, parents' income certificate. Reservation request of such candidate will not be entertained.
Mistake in translation there. It was not entertained originally. By virtue that gave the list to the petitioners to approach this honorable. Because they were not entertained under 12/12/1980 by virtue of 12/12/1986. Therefore, instead of considering them as OBC candidates, their certificates were at the threshold rejected and they were taken under GM.
Now, that's right. Again, the question will be whether you are taking departure from 12/12/86.
No, which is why it is as per the original stand of the state before the learned single judge also, as Malana read out the entire schedule. Even there we took a stand supporting the 12/12/1986 circular. Now, why this peculiar situation arose is because after the learned single judge's order, by virtue of these proceedings, it was decided that in view of the dire need of this one, let us, as in this peculiar facts and circumstances, let us not, if we take a departure from 12/12/1986, they cannot. In fact, people like the appellants would straight away be outside the OBC category because they have submitted their spouse's certificate. if we were to take a departure from 1286, which is why we have not taken a departure from 1286 as a stopgap measure for this particular activity. We have taken them like the appellants who submitted husband certificate, as well as people like the petitioners who submitted the parent certificate, and drawn up a fresh OBC list based on merit.
Without denying protocol agency.
We don't need to.
This is 16 for order. Nobody can deny the constitutional benefits. This is 16 for order. Even a government has no power once it has been introduced under 16 for. It becomes a
Residing from 1286. I am not, in fact, even these proceedings again reiterate 1286, but we, on the next page 14, we say that even though this is the learned single judge's order, we are accepting it since we are in dire need of it. And therefore, a fresh list, list is drawn up by taking both the candidates. So it's neither a departure nor a strict follower of 1286. And to that extent, of course, I can't, and this is the position. It is, so to speak, blowing hot and cold, but in these facts and circumstances, we have decided to take this decision. No,
As long as my annexure F is not disturbed. All that the passenger gives me annexure F, now minutes to say annexure F is itself void. That is not the question. Format is there, it's given in the format. Now the selecting authority minute says, I will not accept annexure F. Now instead of that, let us, if somebody is deprived, yes, I understand. If they are saying your lordship, then ask them to give a cutout of the number of posts so that this doubt itself is clear. They are the best custodians.
You are depriving the social status and the backward by one charge.
Sorry?
It's not a matter which can be settled by activity. How many people will go, how many people will come. It's a question of grammar of the. Grammar should be in accordance with the applicable order. Section 4 of the Reservation Act, which came in the year 1992. It says all executive orders that have been issued under Article 16(4) will be as if they have been issued under this Act. When there is a legislative edict is there as to how family income has to be computed, that can be changed, but only by the legislature. And in the absence of any challenge to it, then they say, we have followed Marital 82 also, we have followed Leonard Single Judge. Can there be any such mix of law and non-law?
This is not the first instance, is what I would say.
Yes, sir.
But we have produced
They
that.
are educated.
Perhaps my management can argue, I am not coming in this way, but to have snide remarks is not a, he has his own theory. Commissioner of backward classes has followed this Surrender Singh and has issued those orders in place before the learned syndicates. There are dividend bench judgments of this court which says parents' income has to be taken into consideration while considering OBC category. Those are taken. The learned syndicate follows those rationale. They raised one later on in this court. That is the answer. Surrender Singh has not followed for the first time by the learned single judge. Division bench has held so. He follows that. The other division bench has held so. He follows that. The commissioner of backward classes has followed that, saying that as per Surrender, there are not certain candidates. Backward class.
Reservation for just one government needs not find another government. Reservation policy of the Union of India need not be followed by the state government. Article 16(4) says Indira Gandhi says it is a policy decision of the state government, and there is no judicial review on it.
See, one thing is very clear. The state has to come here whether or not you are strictly complying with 12/12 and 1986. Yes. Till the stand is made clear, it's difficult.
No figures, madam. Whether you are going.
I want to get figures.
No, he wants to give clarification with the figures.
That is, madam.
No. Figures are not overtaking the clarification regarding 12/12/1986. That stands alone. That issue will stand alone.
Article 16 was the effects for that is a fundamental.
That
This
issue,
time I don't have fundamental.
that issue will stand on its own. That they have to clarify.
Only to assess the damage.
Only to assess the damage, the numbers.
Damage is the numbers.
Correct.
And remedy the damage also. I think all of us are trying to do the same thing. At least I hope.
And also to avoid any future potential litigation in the matter.
Would be avoiding future.
That's the-
potential litigation. would
yes,
be
yes.
the right.
I
Correct.
think your article has passed on the matter went up to Supreme Court recently. My last Gawai, this will be a self-level state court.
We took the chance.
There are 65 people, you are also part of that. Those who have approached the court and the respondent, they must be accommodated. Now the state government took a decision. After agreeing, SLP, that is kept in.
We state our stand as far as that also is.
This bunch of, we'll just seek your response on this. Bunch of appeal challenges the order of learned single judge dated 30th January 23. In writ petition number 23752 of 2022. After hearing the learned counsel for the appellant for a considerable length of time, when certain queries were put to learned additional advocate general, the learned additional advocate general submits before this court that the state government thought it fit to take the stock of the situation pursuant to the order passed by the learned single judge. And a meeting was conducted under the chairmanship of Ministry of Primary and Secondary Education and Sakala Minister on 7/2/23, considering the subject matter, namely recruitment of 15,000 graduate primary teachers. Our attention was invited to the statement of objection filed on behalf of respondent number 1 to 26 state on 18/4/23. The copy of the minutes of meeting is annexed to statement of objection as annexure R1. The third para of the minutes of meeting reads thus, quote, 22,432 candidates are qualified, so and so, so and so, so and so. It's also stated in para 4, a reference is made to the judgment of this, the judgment passed by the learned single judge, and it is stated in clause 4 of the resolution, thus, quote, now as though as there is no sufficient material in the minutes of meeting prompting to frame clause 4 of the resolution and the third paragraph of the minutes of meeting, particularly what were the criterion applied for finalizing the number of candidates to the extent of 22,432. What would be the exact number of the other category candidates after applying the judgment of the learned single judge, whether the state government is desirous of taking a complete departure from 12 December 96 from the departure from the government order dated 12 December 86, or this departure is only to the limited extent of selection of the graduate primary teachers. Thus, these issues are required to be clarified by the state government. As such, the state government is directed to file an additional affidavit giving certain better particulars and details in reference to the queries, in reference to the issues raised by us in the above part of the order. Such affidavit, additional affidavit be filed within 1 week, at least after 1 week.
Whether it could be resolved. I think it is nothing wrong.
There was, while senior advocate appearing for the appellants advanced his submissions on various aspects. One of the submission as a alternate submission of learned senior advocate for the appellant is, as the state government is in need of an urgent need of appointing as good as 15,000 graduate teachers, and the appellants who would be kept out of consideration due to the order passed by the learned single judge are in a very limited number, and as they have submitted their claim complying all the necessary formalities, if the state government is approaching with a fresh exercise of the preparation of list of the candidates, final list of the candidates,
What are the order? Candidates who submitted the income certificate of the father. Exceptional case in this also. Along with the capital. Who submitted their certificate of the father. The para 4 seem to be taking care of the situation. That your application would also be considered.
No, they want to accommodate now. Since we were there in the provisional, final we are going out of it. And if they could accommodate us.
No, that's what para 4 of the
Para 4
resolution.
says that along with those candidates who have submitted their parents' income,
And they are in the list, therefore in the final list they have come. And now I have been weeded out from the provisional list. Therefore, without subject to any exercise,
Clause-
whether the government could accommodate.
therefore clause 4 says so and so candidates and the candidates who have submitted the husband's income certificate who are already in the merit list will be considered on the basis of overall merit, revised provisional 1-1.
Correct. And final list is now out, and we are not there.
After
Based on the new policy. Control 86 and inside.
Since they did not qualify on overall merit, they have now been, but they were considered.
No, that is not, no, that is not the issue. The issue is, based on control 86, I am inside. If without a control, I am out. Therefore, government can accommodate or not.
Initially, he rightly submits, initially they were the part of the provisional list, applying all the other criteria. Now you say that they are not falling in the list
Because some people have also come in.
because they are added.
Why?
Because new policy.
Added because of the learned civil service order and on merit, both combined. So it is not merely taking one name.
No, so
transplanting him
what
with
was that
another.
other merit consideration then?
For 100 people, yes, ma'am, which is not submitting. Supposing there are 200 applicants for 100 OBC posts.
Only will say that if the state government can consider to accommodate these appellants, the state government may also make that stand clear in the additional affidavit. Yes. It's clear that we will. Monday. 28 Monday. We'll say that the additional affidavit be filed on or before 24th August and matter will be listed on 28th August, so that you will have opportunity to go. No, 28th we'll try to. There's only one matter at 2:30. We'll say that this serial number 2. Serial number 2. Interim order if any to continue. Same claim, you are also, yes.
Service is incomplete. Service is incomplete in this matter.
Sales for 5 first thereafter.
Service, then all these two other cards.
All the more reason government to consider fresh recruitment process.
Okay, in the appeals, so delay condonation application for the reasons in the application as well as supporting affidavit, the delay condoned. Notice,
You to appeal also.
notice you are not served, some other parties,
Served statement of objection also, I served them, they.
it is submitted, the respondents are being represented to their respective counsels. SS office objection is waived. If any copy, if anybody remain to be served, immediately give him a copy.
Your interview number?
Which is,
You to appeal also in the applications.
is allowed, we can applications to be allowed, delay condonation application allowed. Objection waived, if you are not given copy, immediately give the copy in your appeal also, if there is something.
We are not parties to the letter in that. Some of the after that.
Yes, delay, we are condoning the delay. Yes, Mr. Deshmukh, yes, what is your matter? Yes, already we have kept a special matter at 2:30 and requested the. No, therefore, that where there is urgency, we are listing it tomorrow. The other two matters, will list them after 1st of September. Any date. Yes, take any date after 1st of September. Yes, where you say that there is very, it's a dire urgency, we are taking it tomorrow. Yes.
My lords,
Other matters after.
serial number 73 is parted matter, my lords. 73, that Corporation Road and my lords, any day next week, 2:30, my lords.
Right now, it will be possible only after 1st September. Already we are in some partner matters. In other days, already even 2:30 certain matters are fixed. If you want some date, it will be possible only after 1st September.
Please. Any date at 2:30, my lords, in 1st September. After
And that's being spoken to.
we had to connect to 5,000 completely and music. Connect to was the start of 14th of August,
When do you want?
right? Tomorrow, Friday.
Tomorrow. Yes. When do you want?
33 some date, my lord.